Supreme Court of the United Kingdom, the highest court in the land.
The Supreme Court was established in 2009, replacing the law lords who sat over the road in Parliament. It is the ultimate decision maker of all UK cases except Scottish criminal cases. There are 12 justices with specialities ranging from family law to commercial and constitutional law. They are appointed by an independent commission. The Supreme Court can reverse decisions of the lower courts. The lower courts then have to abide by them in all future cases.
The layout of the Supreme Court is designed to be user-friendly. The justices sit on a large curved table, the barristers opposite. There is no witness box or jury, but the public can just take a seat and watch the brightest legal minds at work.
The justices wear ordinary work clothes, but the former Supreme Court President, Lady Hale, was rather well known for wearing glamorous brooches.
In 2011, it was decided that lawyers in the court no longer had to wear wigs or gowns. So, I won't need this then.
Above all, the Supreme Court protects our civil and human rights. The rulings of the court can strongly influence Parliament to change laws, as shown in the 2018 case of allowing heterosexual couples to enter civil partnerships.
And when the government increased employment tribunal fees, the Supreme Court ruled it was unlawful, so the government dropped them.
What do we get? Justice!
In criminal law, the Supreme Court ruled that the law relating to joint enterprise, often used to convict defendants in gang-related cases, had been wrongly interpreted for 30 years. In spite of the court's ruling, Parliament hasn't changed the law.
The most controversial area of the Supreme Court's work is judicial review. Judicial review is where individuals can challenge the decisions made by the state. Two cases in particular after the EU referendum had huge political consequences. In both these cases, a panel of 11 justices sat, as these were cases of high constitutional significance.
The first was the Brexit case brought by businesswoman Gina Miller over the method of leaving the EU.
The Supreme Court rules that the government cannot trigger Article 50 without an Act of Parliament authorising it to do so.
Arguably of even more significance was the question of whether the Prime Minister Boris Johnson had lawfully suspended Parliament in September 2019. This case was again brought by Gina Miller.
Millions tuned in to watch the justices unanimously rule that the Prime Minister had unlawfully prorogued Parliament for 5 weeks.
The court is bound to conclude, therefore, that the decision to advise Her Majesty to prorogue Parliament was unlawful.
Hot on the heels of the prorogation case, the Prime Minister made his feelings very clear against the judgment. 3 months later, in the Conservative manifesto, Boris Johnson said there would be a Constitution, Democracy and Rights Commission that would examine the relationship between the government, Parliament and the courts, arguing this would restore trust in our democracy.
A few months after the pledge in the Conservative manifesto, the government has launched an independent panel to look at the judicial review process. The panel of experts will examine if reform is needed. The government has said that courts are taking decisions that should be taken by Parliament and the government. The government has also said that there could be parliamentary hearings for new nominees to the Supreme Court.
The Supreme Court has a vital role in our Constitution in influencing laws that Parliament makes or that others break. But there is no doubt that its role is very much under the political microscope.